40.
Break the court, please.
Good afternoon. May it please the Court? If I may, I'd like to reserve 3 minutes.
Yes, sure.
Thank you. Your Honors, the Second Department's ruling in this case that the defendant's period of probation began to run on the date he was incarcerated violates the plain language of Penal Law 6515, and accordingly, that decision should be reversed. Your Honors,
what about 60012D? Isn't that a more specific statute?
Yes, Your Honor. 60012D, the split sentencing statute, specifically regulates the sentence that the court may impose. It says repeatedly, it says when the court imposes a term of imprisonment together with a term of probation, these terms shall not exceed the statutorily mandated period set forth in Penal Law Section 65. 60012D does not say that a term of imprisonment served together with a term of probation shall not exceed that statutorily prescribed period. And that language cannot be read into the statute. Your Honors, the legislature...
If you don't read it that way, do you create a disparate situation between individuals that can afford to post bail and those who can't afford to post bail?
Your Honor, there may be a disparate situation between defendants who can afford to post bail and those who cannot, but the legislature was well aware of this. It's well aware of the frequency of pre-sentence detention time, and in the context of a sentence of imprisonment has made an accommodation for this. In Penal Law Section 7030, subsection 3, the legislature has said that when a defendant serves pre-sentence jail time and then is subsequently sentenced to a period of incarceration for that crime, the pre-sentence jail time shall diminish the sentence of incarceration subsequently imposed.
But it doesn't diminish the probation.
That is correct, Your Honor.
As I understand the disparate situation, am I confused? This is actually more favorable to the guy who can't post bail?
The person who cannot post bail winds up with a shorter probationary term. That's correct, Your Honor.
So it's better to be poor than rich?
I guess so, Your Honor, under that construction.
A rare event.
The legislature has specifically not said that pre-sentence jail time should be credited towards a subsequently imposed probationary term. And the defendant doesn't argue such for a straight sentence of probation, only in this split sentence context. But the statutes don't state this much. The defendant's focus on the amount of time served instead of the sentence imposed is misplaced because the statutes at issue are not written this way. The Penal Law 60012D, Penal Law Section 65, and Penal Law 6515 can all be harmonized when they're read as written to govern the amount of time of a sentence that's imposed.
Well, the First and the Second Department read it differently, and that's why we're here.
Yes, Your Honor, exactly.
So there is a rationale that is employed in the First Department that's
that we would urge this Court to adopt.
Okay.
We believe that the First Department has correctly decided this issue and that the decisions of the Second Department and the Third Department were incorrectly decided and are inconsistent with the plain language of the statutes involved.
And you rely principally on 6515-1.
Yes, Your Honor. I rely principally on 6515-1 that says a term of probation commences on the date it's imposed, but I also rely on the plain language of 60012D, which regulates the sentence imposed. Looking at the statute, it repeatedly discusses it in those terms. In any case where the Court imposes a sentence of imprisonment not in excess of 6 months, it may also impose a sentence of probation. Nowhere in that statute does it discuss a sentence that, not a sentence of the term, but the amount of time that a defendant might serve. And the fact that defendants frequently serve some pre-sentence jail time was well known.
It's setting out a protocol for splits, right, for split sentences.
That's correct, Your Honor.
So we have to try and understand what it says, right?
That's correct, Your Honor. And what it says is that when there is a split sentence assigned, a term of probation, in this case for a felony, of a sentence up, a period of incarceration up to 6 months and a probationary term of 5 years, those shall run concurrently and shall not exceed the statutorily prescribed time for that, for the felony, in this case, 5 years. Penal Law 65 does not create the exception that the defendant argues it does.
Is there a public policy reason for us to I mean, you're asking us, we're being asked to come up with a rule, I guess, to choose. Is there a public policy reason that favors our choice of the rule you propose, or the way you propose we should read the provisions, as opposed to what your adversary is asking for?
Certainly there is, Your Honor. As this Court has certainly recognized, there are different goals for a sentence of probation and a sentence of incarceration. And a probation term differs from a prison term in that it's intended to afford the sentencing court an opportunity to monitor the defendant's behavior in the community to determine if its confidence is misplaced. The purpose of the conditions of probation don't attach until the sentence of probation begins. And it's important that, since the penal law has set forth that the probationary term begins on the date it's imposed, that that is respected and the terms of probation are allowed to have their full effect.
From a policy perspective, even if it results in unequal treatment in terms of a different situation?
Yes, Your Honor. The legislature was fully capable of addressing that situation, as I previously argued.
And you think their intent was to provide unequal treatment in those two situations when there's bail and there is no bail?
I'm not sure the intent was to provide unequal treatment, but if they wanted to cure that reality, they certainly knew how to do so and did so in Penal Law 7030, subsection 3, when they did so in the context of a term of incarceration. When a pre-sentence jail time is served and a subsequently imposed term of imprisonment is imposed, the same goals are served to some extent by both. It's a period of segregation from the community and incarceration. But the same can't be said of pre-sentence jail term towards the goals of probation. They aren't satisfied by the time that is spent in incarceration, and the legislature apparently did not see fit to diminish a subsequently imposed probationary term by the amount of pre-sentence jail time that is served.
So in order to achieve the result that your adversary wants here, the sentence would have had to have been 6 months in jail and 4.5 years probation?
The result, yes, that my adversary result. So, Your Honor, our argument is not that the term of probation is sacrosanct, and certainly, as the defendant points out, the court at its discretion can modify, alter, or even terminate a probationary term prior to its expiration. But the statutes certainly don't allow that by operation of law, a probationary term should be less than that imposed because of a pre-sentence time spent in detention. A probationary term can certainly be shorter when the court in its discretion decides that the defendant's actual performance on probation warrants some modification of the sentence of probation that was originally imposed. The court didn't see fit to do so in this case, and the defendant was still on probation when the violation of probation was filed, and the Second Department erred in concluding that was not so. If the Court has no further questions, I'll reserve the rest of my time.
Good afternoon.
Counsel?
It seems to me that under the plain language of the relevant statutes, the defendant gets credit when he has served part of his jail term or all of his jail term of the split sentence, that's credited. And there are two statutes that I think make that point very clearly. The first is 6001 subdivision 2D, which says in any case, without exception, in any case where the court imposes a sentence of up to 6 months, it may also impose a sentence of probation, provided that the term of probation, together with the term of imprisonment, shall not exceed. Now, it talks about what sentences the court can impose, but it doesn't draw a distinction between the sentence imposed and the sentence that the defendant has to serve. It says in any case when the court imposes a split sentence.
The phrase term of imprisonment means pre-conviction and post-conviction jail time?
The term. Exactly, because the term of imprisonment.
Do we know that's what that phrase means?
Well, Your Honor, it's saying the court may impose a sentence of imprisonment not in excess of 6 months. So it seems to me when they're saying the term of imprisonment, they're talking about the 6 months or whatever that might be. So in a 6-month split, which is what you had here, there's a 6-month jail term and there's 5 years of probation. And it says provided that the term of probation, together with the term of imprisonment, shall not exceed the term of probation allowed by the...
I guess then the question is, how does Section 65 play into that where it says imposed, which seems to sound more like the pronounced sentence rather than the pre-conviction jail time?
Except that this section does say the term shall not exceed, and the terms together shall not exceed, and the terms together are, the term is 6 months and the 5 years.
And assuming the defendant had been incarcerated for 6 months or less,
Right.
It would have been time served.
And that would amount to the 6 months, and then he would serve the balance of 4.5 years
But
on
he was serving
probation.
his term even before it was imposed.
Exactly, Your Honor, yes. And I think we...
Is it relevant that these two sentences were apparently written at different times? When this statute was originally enacted, it said the term of probation together with the term of imprisonment shall not exceed. At that point, they were separate things, and the term of probation and the term of imprisonment were added together. Then later on, they add a sentence that said they run concurrently. Well, if they run concurrently, it doesn't make any sense to add them together. I guess I'm really saying, doesn't the second really change the first?
Well, the second sentence I don't think does change the first, because this Court decided the case of Pirro versus Angelillo in 1996 and specifically considered that last sentence that was tacked on and said that it was sort of unclear why, but that its purpose was to deal with intermittent sentences.
Yeah, but it was before it was enacted, you weren't on probation until you'd done your jail sentence or your prison sentence, correct? You did your 6 months first, then you were on probation.
No, I think this, the main part of the statute before that sentence was tacked on was then what it is now. I mean, you get 6 months plus probation.
Why would the legislature talk about adding the two together? The term of probation or the term of probation or conditional discharge together with the term of imprisonment. They're talking about making a sum. You don't make a sum of concurrent sentences.
Well, the statute may not be worded as wonderfully as we would like, but it says the term taken together shall not exceed the term that you could give for probation. So that means they have to be concurrent. So in a sense, it's sort of almost surplusage that they added that other sentence later on. But I think that statute is not really the be-all and end-all, because then you have in Section 65, subdivision. This is the section that designates how long a term of probation is supposed to be. And in subdivision 3, it says for most felonies it's 5 years, and for this it's so long and so forth. But in subdivision 2, it explicitly recognizes that in this split sentence situation, the statute 60012D trumps those periods. Because what it says in section 65.00 subdivision 2 is sentence. When a person is sentenced to a period of probation, the court shall, except to the extent authorized by 60012D, impose the period authorized by subdivision 3 of this section. And that's the 5 years. So I think it's saying, okay, this for a felony, for most felonies, it's going to be 5 years. And that's what the court's supposed to impose, except when you're dealing with a split sentence. And then the exception comes into play to the extent authorized by 60012D. And that says they can't exceed 5 years.
There's no dispute that the time spent in prison reduces the time spent on probation to the extent that it's after sentencing. This case is about what happens to the time spent before sentencing, right?
That's right.
I mean, but I guess my question is, if they the statute says that they run concurrently, the probation and the prison sentence run concurrently.
Right.
How can they run concurrently at a time before the probation sentence existed? How can you run concurrently with a non-existent term of probation?
Well, they can't run concurrently until, in a sense, until they're imposed. But I think the statute means more than just they run concurrently, because completely apart from that later sentence that says they run concurrently, it says provided that the term of probation together with the term of imprisonment shall not exceed the 5 years in this case.
There isn't anything in the legislative history that refers to time served, is there? Did I miss something?
No, I don't think there's anything in the history at all that's helpful. What says most about the history of this statute is this Court's decision in Pirro versus Angelillo. And I think that's instructive, because in that case, what the Court says is that the core part of the split sentence is the jail term. And the flexible additional part is the probation, which suggests that the probation, the amount of time you serve on probation can be less depending on what jail term you've served. And let me just address the disparity here, because I think this is sort of at the heart of what the problem is if you read the statute the way that people urge you to. And it would discriminate against, punish more severely, the indigent defendant. And bear with me for a minute while I give you an example. You have 3 co-defendants who are arrested for the same thing. Bail is set at $1,000 for all 3. Eventually, a few months down the pike, they all get sentenced to a 6-month split, 6 months plus 5 years of probation, okay? Under the people's theory, the guy who made bail immediately, he's got the money, he makes bail, he's going to be sentenced, he's going to do the 6 months in, and then he's going to get out, he's going to be on probation supervision for 4.5 years. Second co-defendant, took him 2 months to scrape up the money. He's done his 2 months. Now he gets sentenced to the 6-month split. He's going to do the rest of the 4 months. Then he's going to be on probation, not for the 4.5 years. He's going to be supervised for the 4.5 years plus the extra 2 months if he's not getting credit for what he did in. Third co-defendant, he hasn't got a penny. Family can't come up with anything. He does his whole 6 months before they all get this identical deal. From the time, he's done 6 months already, but he's going to be on probation, unlike the guy who's going to be supervised for 4.5 months. He's going to be, 4.5 years, he's going to be supervised for 5 years.
But of course, all 3 of those have their probation end on the people's theory on the same day.
That's right. But one guy has done...
And the statute does say that probation begins at sentencing.
Yes, 1615 does say that. The statutes do seem to be in something of a conflict.
And I understand the inequity you're talking about, but isn't there a policy there that says we want to keep an eye on these guys from 5 years from the day they're sentenced, and we don't feel comfortable until they've been sentenced for 5 years have gone by and they've stayed out of trouble?
Well, Your Honor, I don't think that's necessarily true, because all sorts of things, and I pointed out a bunch of them in the brief, alter the period of probation along the way. Or the court could set some termination date from the get-go. Once you've completed community service, you'll be done with probation. There are all sorts of things that alter the length of probation. There's nothing sacrosanct about the 5 years.
Is it also true that a judge could pronounce a sentence non-pro-tunc dating back to the date of the arrest?
Yes, Your Honor, a judge could do that. A judge could also give a flat sentence of probation, and then this wouldn't come into play. This only comes into play when the judge gives a split sentence. And I would suggest that the wording of 6001, that in any case that it can't exceed the term of probation, in most cases the 5 years, would be rendered meaningless in the majority of cases, because very few people make bail the instant they're arrested.
So what happens if your indigent defendant who's in jail for 6 months, but then the sentence that's imposed is 5 years probation? When does that begin to run?
If the sentence is imposed is 5 years probation, he serves 5 years probation.
There's no
After
credit.
his-
There's no credit.
You're not reducing.
That's correct. You're not reducing it. But if he gives
Why is that? If it's a split sentence, you are reducing it.
Because the provision that says it can't exceed the 5 years is the split sentence provision and applies solely to that. There is no general provision that jail time is credited against probation. That's absolutely right. Not as a general rule. And if you look at the May case, and there's another case cited in the briefs.
So your argument's really founded on subdivision D, because
Exactly.
it's the language used in the split sentence provision.
Exactly. On that and on Section 65, Subdivision 2, which says the period shall be, as in Subdivision 3, except to the extent authorized by 6001 2D. And I think it's, the legislature obviously did not want to credit vast amounts of time toward probation. They didn't want to take a 5-year presumptive probation period and reduce it by, say, 3 years or 2.5 years or something like that, so it's a dramatically lower amount of time. And that's what these, the second and third department both, you know, their policy is not, we credit a guy, if he gets a split sentence, we credit him with all the time he has in, even if it's years. That's not it. The maximum he can get credit for is the amount of time of the jail term portion of his split sentence. So if it's 60 days plus probation, the most he can get credit for is 60 days. If it's 6 months plus probation, the most he gets credit for is the 6 months.
Even if he's been in jail for a year?
Even if he's been in jail for a year, because there is no general provision that says he gets jail credit time against probation. It's just in this situation where you have the split sentence.
So 65-2 subordinates the general direction
To the
for
specific.
the split provision.
Exactly.
In your,
Yes, that's exactly so.
And does the pre-sentencing and period of incarceration have to be in connection with this crime? Or can
Yes.
they use time they're serving on another crime? If they're already incarcerated for some other violation?
No,
some
there
other
are
crime.
there's some separate statutes that deal with what can be concurrent if you're, because they don't want people to be on probation and parole at the same time and things like that, but that's completely separate from this. I don't think that this would have to be the time you have in on this case. Wouldn't be imported
The
from
fact
some
is,
other
you would have to
case.
be eligible for straight probation in order to even be talking about this. And the 6-month split would just be an accommodation, because really the sentence is 5 years of probation.
Well, Your Honor, if he's done his 6 months already,
Well, up to 6 months.
up to 6 months, well, but, I mean, I think the general thinking is that a split sentence is a worse sentence for defendants than probation as a rule. And the whole idea behind split sentencing is that you give someone a relatively short period because the crime isn't so horrible, but then you also have them supervised for a time afterwards. So it's sort of a hybrid in between a more severe sentence and a more severe incarceration sentence
But
and
the
probation.
fact is that there is no such thing as a sentence of 6 months for a felony, standing alone.
That's correct. It's
So-
only the split sentence.
So the sentence is actually 5 years probation, and whatever the split is comes off the front.
Well, it sort of depends on how you look at it, but this court in Perot versus Angelillo said that the core provision is the, let me see if I can just find it quickly, that the core provision, the term of incarceration was intended to be the fixed or core element, and the probationary sentence was intended to be the flexible variable. And if you look at the Attorney General's report that we cited in the brief, that harmonizes all these statutes and basically says the total period is the 5 years, and if you do a 6-month split, you do that 6 months, then you do 4.5 years
Okay,
of supervision.
okay.
I'm sorry, can I
Go
interrupt?
ahead,
I mean,
Judd.
does this depend in any degree on whether we look at probation as being punishment or as serving a rehabilitative purpose? I mean, I understand your point, there's an inequity. As the poor guy, when you add his jail and his probation time together, is doing more time than the
Right.
rich guy.
Right.
But if you view it as a rehabilitative rather than a punitive measure, isn't it best to be sure that we get the full measure of rehabilitation? Isn't that the underlying policy?
Well, Your Honor, if someone gets a 6-month split, they're going to do 6 months in jail, and they're going to do 4.5 years on probation. If 4.5 years isn't going to rehabilitate them, I don't know that 5 years is going to rehabilitate them, and I think the legislature figured that. They figured we're not going to just give blanket credit, because if the guy's been in for 2.5 years, we're not going to put him on probation for 2.5 years for a felony. But in this situation, 4.5 years to 5 years is a reasonable time period, and that's enough. It's either enough to rehabilitate him or it isn't. That few months isn't going to make
Okay,
that
Counsel.
difference.
Thanks.
Thank you.
Your Honors, the defendant is asking this court to import a lot of language into 6001 2D that simply does not exist there. The defendant is arguing that nothing would prevent a court from crediting a defendant for a full amount of pre-sentence jail time, but merely because the Second Department and Third Department have not gone this far yet does not mean that their interpretation of the statutes would not allow this result. In addition, the statute doesn't say anything about the pre-sentence detention time being in connection with this crime. That certainly is the language in 7030 that addresses specifically credit for pre-sentence jail time.
You're saying the statute that if your adversary wins the case, the statute could be read in effect to allow a year's credit against probation?
I certainly don't see anything.
How can you read it that way?
Pardon? I don't see anything in the language that would limit the amount of time credited, because I don't think the language of the statute addresses in any manner pre-sentence jail time being credited towards a subsequently imposed split sentence or probationary term.
You can't do this for over 6 months incarceration.
Pardon me?
It could not run for a year. Isn't that so? The maximum you can do a split is 6 months.
Yes, Your Honor, but in pre-sentence detention time, I guess it's possible that he could have been in pre-sentence detention for 9 months before sentencing. And then, although it would only satisfy 6 months, it would fully satisfy the 6-month period of incarceration, I don't see anything in the statute as written or the case law that would prevent a court from saying it takes an additional 3 months.
The statute seems to say that when you add up the term of imprisonment and the term of probation, they got to come to 5 years.
The sentence imposed, yes, Your Honor, and I believe that that is correct. And Section 65 of the Penal Law, the except clause in that, does not mean that 6001(2D) trumps the statutorily mandated sentence of probation articulated. If you look at Section 65 of the Penal Law and look at some of the other subsections, subsection 1 as well, you see that the except clause merely means that an exception to a straight sentence of probation is a sentence of probation that might include a term of imprisonment. So all it means is that the 5-year period can include, in the context of a split sentence, a period of time that might be spent in imprisonment because they run concurrently. It does not mean that a sentence of less than 5 years is permitted. Ultimately, as the Court pointed out, these sentences run concurrently, and it just can't be that a defendant is on probation, period, prior to the date on which he's sentenced. As this Court recognized in Rodney E., there's no statute which expressly or by implication permits a court to place a person convicted of a crime on probation before her sentence is imposed. And that is, in essence, as a practical matter, what the Second Department did here by determining that his probationary sentence began on the date he was taken into custody and not on the date the sentence was imposed. Because this conflicts with Penal Law 6515, that decision should be reversed.
Okay.
Thank you very much.
Thank you.